This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about the problems when you waive the requirement for a proof of loss, and when to reject a claim for lack of a proof of loss, the insurer must have acted continually to enforce that condition, and failure to do so can be fatal to the insurer's position. The last time a 60-day limit to file a proof of loss was upheld was a case called White versus Home Mutual, 128 California 131, decided in 1900 and issued by the California Supreme Court. It was a Draconian decision, with Mr. White only a few days late, and the Supreme Court upheld the denial. Currently in Indiana, after a hailstorm damaged a condominium complex's 9 residential buildings, their insurer promptly investigated the claim, made 3 separate payments totaling nearly $30,000, and engaged in 2 years of ongoing negotiations. The insurer then sought to deny coverage entirely after the insured sued because the insured failed to submit a sworn proof of loss within 60 days of the loss. The trial court granted summary judgment in favor of the condominium complex, finding that the insurer had waived its right to enforce the requirement. The insurer appealed in Property Owners Insurance Company versus Wildwood Court of Munster Condominium Association, Inc., a decision of the Court of Appeals of Indiana on October 25, 2024, claiming it did not waive any condition. A forensic engineer, however, retained by the insurer, inspected Wildwood's property in September of 2021. Wildwood's public adjuster provided the insurer with estimates for the replacement cost value and actual cash value of the alleged hail damage. The estimates called for removing and replacing the roofs on all of Wildwood's 9 buildings. Submitted with these estimates were photographs of the hail damage and a weather report from the day of the hailstorm. Wildwood's adjuster, engineer, and the insurer's engineer and the insurer's field claim representative jointly re-inspected the buildings on November 10 of 2021, and the insurer made 2 additional payments on November 24, 2021 and January 7, 2022. 2 months after the 3rd payment was made, Wildwood sued the insurer for breach of its insurance policy due to insurer's failure to pay for new roofs on Wildwood's buildings. The trial court granted partial summary judgment in Wildwood, ruling that the insurer had waived its coverage defense. Where a policy provides for notice and proof of loss within a stated period, the insured must comply with that provision as a condition precedent to recovery under the policy. Viewed most favorably to the insurer, the undisputed designated evidence shows that the insurer's pattern of conduct was inconsistent with an intent to enforce the sworn statement and proof of loss requirement. The insurer paid for some of the storm damage covered by the policy more than a month before the proof of loss was even due, notwithstanding the language of the policy. The insurer's actions were inconsistent with strict enforcement of its policy provisions, despite the insurer's statement in a letter to the insured that partial payment of the claim was not a waiver of any policy conditions, but by paying part of the claim before Wildwood's submission of the sworn statement and proof of loss, the insurer essentially contradicted the policy provision providing for payment of the claim only after Wildwood's submission of a proof of loss. The only significant dispute was over the extent of the shingle damage and the quantity of shingles to be replaced. After both parties had invested nearly 2 years of effort into ascertaining and negotiating the scope of Wildwood's claim, Wildwood sued, only to have an answer filed claiming that Wildwood breached the condition by not filing a proof of loss within 60 days of the loss. The insurer could have claimed the policy terms allowed it to reject coverage as soon as August 2, 2020, the deadline for the sworn proof of loss. Instead, the insurer invested time and money, as did the insured, into further investigation and partial payment of Wildwood's claim. The court concluded that the insurer's conduct over the 2 years before Wildwood sued was inconsistent with an intention to rely on the policy requirements, that is, the timely submission of a signed sworn statement of loss. The insurer's conduct led Wildwood to believe that the insurer disputed the scope of the claim, not that the insurer disputed whether any coverage was available. The insurer's conduct sent a clear message to Wildwood that the insurer was not enforcing the proof of loss requirement of the policy. Wildwood was therefore entitled to partial summary judgment because of the insurer's waiver negated the coverage defense on which it sought summary judgment. The insurer was not entitled to judgment as a matter of law. In my opinion, insurance is nothing more than a contract. The insurer, unlike the insurer in White v. Home Mutual, did not deny the claim for lack of a proof of loss on the first day that the right was available, the 61st day after the loss. Instead, it acted as if the proof of loss was not a condition by making multiple payments both before and after the expiration of the 60-day limit. The public adjuster could have avoided the problem by simply asking for a written extension of the time to file, something that insurers grant without even thinking, but was lulled into not producing a proof of loss by the actual partial payments of the claims. Apparently no one on either side thought about the time limit until a lawyer filed an answer to the complaint asserting the failure to timely submit a proof of loss as a defense. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 4,900 blog posts. You can also subscribe to my Substack publication, where you will receive for a very small fee detailed information about insurance, insurance law, insurance claims, and insurance fraud. And please tell your friends and colleagues about the blog and these videos. And if you watch or subscribe to the free videos, you can also click on the like button on YouTube or the thumbs up button on rumble.com. Thank you for your attention.